National Internal Revenue Code says that insofar as the ITR is concerned, the commissioner must seek the permission of the president, which he said she did in writing. So, in other words, no matter how public our hearing is, the rules of secrecy must be followed. There is no exception to that. It is a public trial, but order must be maintained. Otherwise, it's no trial at all. That is the reason for this trial. A trial assumes order, system. If without it, then it's useless. That is all. I don't want to argue with anyone on that. I just want to call the attention so that henceforth we will follow the rules. Thank you, Mr. President.
And I would like to state for the record that that was precisely the reason why what the chair cautioned the private prosecutor not to go into the substance of the document, meaning the contents, because the Commissioner of Internal Revenue was brought here to testify on the documents that she brought and whether they were unauthentic documents, meaning that they have conformed with the formal requirements of the statute, and to present those documents, because those documents are the best evidence of the contents, whether there is any income tax or income reported and whether taxes were paid. There's no better evidence than the income tax. Of course, in the supporting receipts. No? So I hope we will adhere to these rules so that we can move into the trial smoothly. No? I could not object to the questions relating to the substance because I'm the presiding officer. So, but I cautioned, the record will show that the chair cautioned the private prosecutor in delving into the contents of the documents that were presented by the Commissioner of Internal Revenue. In fact, even the alpha list, I said the best evidence of the alpha, the contents of the alpha list is the alpha list itself. So with that, now I would like to hear the pleasure of the defense counsel.
Thank you, Your Honor. We had always been emphasizing and with positive articulation, Your Honor, that when it comes to documentary evidence, there is a process that is ordained under our rules of court and procedure, that there must first be identification, there must be marking, and there must be an offer, and the party against whom it is offered must have the opportunity to comment and or object. And it is only after all these proceedings have taken place that an order of admission or rejection can be properly made by the court, Your Honor. Now, we wanted very much to bring to the attention of this honorable court the violation of all these things relative to confidentiality and so on, Your Honor. But for fear that we may again be accused of delaying the proceedings in this case, we have chosen not to. Now, they have brought this matter very openly. In fact, when we were still on trial here, our people told us that they were already discussing this issue in these conferences being held, Your Honor. Now, we have no way of stopping them, Your Honor. It is their pleasure, and all we can say, or all our spokesman said was, this is not evidence as yet, because they had not yet been offered, neither had the court ruled on their admissibility. That's the only manifestation we have made, Your Honor. We have never discussed. We do not want to engage them in a discussion relative to the contents of the document, Your Honor. Now, we are very sure that all these things should not have happened if all the parties concerned, more especially the spokesman of the prosecution, that we should avoid discussing the case on the merits. we are not presenting this evidence so that the public will know what is our purpose, what are the proceedings taking place in this court. So much so that until and unless a formal offer is made of this documentary exhibits and a ruling is made, then this shall not be considered as evidence in the case, Your Honor. Now, with respect to the comment that they are not public documents, I'm sorry that I may not agree with the honorable gentleman from Makati, because the nature of the document is determined by the contents thereof. Has it been notarized? Was it executed before a public official duly authorized to administer oath? If that is the case, then it is public document. The element of being offered and admitted in a judicial proceeding does not go into the character of the evidence presented, Your Honor. Now, there had been likewise statements here made by the private prosecution, Your Honor, relative to the basis of their complaint. And there was a mention that had been made of several articles, Your Honor. May we be allowed to state for the record that there is nothing in their complaint, impeachment complaint, which alleges the particular acts or omission constitutive of the violation. And that is elementary in criminal procedure. The acts or omissions constituting the offense must be specifically alleged. There is no allegation of that sort, Your Honor. Hence, we were not able, and we did not choose to discuss this matter in our answer, Your Honor. It is not correct and accurate to state that the basis of their action for this impeachment complaint, Your Honor, are the various sections of the anti-graft law. And secondly, the court will probably agree with me, and so with the rest of the honorable members of this court, that there is no statement here relative to to the violation of the anti-graft law. What they said is failure to disclose and so on down the line, and there is a violation of public trust, there is culpable violation of the Constitution, but never violation of the anti-graft law. If we found that, first, our first impulse was to file a motion to dismiss, Your Honor. But we are prohibited, and we are afraid and apprehensive that this may be raised as an argument for us delaying the case. There was also a suggestion that we should have filed the motion for a bill of particulars. We do not agree with that kind of a suggestion, Your Honor, because a motion for a bill of particulars alleges, or for purposes of merely making the unspecified or definite allegation to be more concrete and definite. Here, there are no allegations whatsoever. So,
and besides, counsel, if you will file a bill of particulars and the articles of impeachment are wanting, an amendment would be the proper remedy. And if you amend the articles of impeachment, it has to go back to the House where it came from for amendment. It cannot be amended by the prosecutors. It has to be amended by the House, and that amendment must be voted upon.
And that goes into initiation, Your Honor. And we are of the humble submission, Your Honor, that this will require that the complaint for impeachment must undergo another proceedings before the House of Representatives. Again, maybe there will be crying hell. O alam na ninyo, ayan, ginawa na naman ng Defense Counsel. Gusto lang nila ma-delay, babalik. But when we argue our points, Your Honor, when we object to a particular question, it is not because we just wanted to object. Because this is part and parcel of the right of an accused to due process. If there is no more opportunity to object, there is no more opportunity to argue, then what are we here for?
Senator Santiago, Mr. President.
The majority floor leader.
Senator Santiago wishes to be recognized, Mr.
Thank you,
President.
Your Honor.
The gentle lady from Iloilo.
Thank you. Under the rules of court, no party is allowed to present evidence unless that evidence is relevant to the charges contained in the complaint, or, as in our case, in the articles of impeachment. That is the general rule. You can admit evidence that is not related to any of the charges in the complaint only after you have amended the complaint. Now, my query now is presented to both counsel and to my brothers and sisters in the impeachment court is this, and I will not necessarily request for an answer at this time, maybe memoranda. The question is this: what is the time frame for amending the complaint or the articles of impeachment? Can you amend at any time, or is there a deadline? If the council are interested in this question, may I offer the suggestion that they should file memoranda so that at caucus, the Senate court might discuss this among ourselves.
May I be allowed to present the view of the defense, Your Honor?
I think the counsel for the prosecution has stood to make a remark. We'll allow him first.
May I be allowed to present some manifestations
Proceed.
or comment? Thank you, Your Honor.